right, Mr. Staples, again, three choices, or fill out the form, turn off the camera, or we can raise your contempt again if we're court rules. So, any choice?
I'd like to give my oral argument here too. Before we move forward on this, if I can say a few things.
About the camera issue?
About this, yes, this entire situation, this whole contempt thing.
Well, we're gonna have a contempt hearing, if that's what you wanna do.
Sure, we can have a contempt hearing, right? Do you want to do it right now, or do you want to put me in the back real
We're
quick?
gonna take you into custody.
Take me into custody, and then we'll come back. So leave all my stuff here? I'm not turning anything off, and you can't turn my things off either. That would be destruction of evidence. So you're on notice that if anyone shuts off any of my
Let me
devices.
give you one additional warning, okay? I'm aware.
Welcome everybody. I'm back, breaking the flaw here to cover Frank Staples. He's held in contempt for an unregistered vehicle charge because he was recording his own trial. We're going to go in now and we're going to go to his contempt trial and we'll see how it goes. The original video of him being arrested, definitely go over to Absolute Defiance and the link will be in the description below. So please check that out before you watch this video and then head over and come back watching this.
Okay, preliminarily, we're here in the matter State versus Frank Staples, 25 CR 0412. Mr. Hart, it's you?
Yes.
Okay, I see you filled out the form to video record. Appreciate that. As long as that camera stays there, doesn't become a disruption to the proceedings, you're all good. Assuming the state has no objections.
No objection to the statement.
Great, very good. Mr. Staples, I see you have a body worn camera.
It is here.
The camera there. It's on your chest.
Sir.
The
What?
camera as well?
This is a rig to put it on my chest.
Okay.
Yes.
Is the camera running?
It may or may not be running. I have a right to privacy.
Okay.
under the
Did you fill out the form?
Why would I fill out a form? That's for the public to record someone else's hearing.
Okay.
So this
Anyone
is,
coming into the courthouse, the courtroom to record has to fill out the form. I know that you went over this with Judge Tenney in the previous hearing. I know that you were found in contempt because you refused to fill out the form.
Sure.
So I'm gonna ask you to fill out the form.
You're gonna hold me in contempt too?
If I have to, I
Sure,
don't want to,
that's
I'd like you to just fill out the form.
So,
So here's the thing, I'm gonna give you 5 minutes to make a choice. As I see it, you have 3 potential choices. One is you fill out the form, and we get to the merits of this case, which is what I really want to do. 2 is you don't fill out the form, and I have to hold you in contempt.
you do? The state's not objecting to me.
I'm going
Recording
to
on.
uphold the court's
So you're going to enforce, you're gonna sua sponte,
I'm going to
raise
enforce the
this on
court's
behalf
rules.
of them without,
It's not on behalf
hold
of
on.
them.
It is on them, because they didn't object
Sir.
to me,
Sir,
the
I'm
pro
going
se
to-
party.
I'm going to enforce the court's rules.
Oh, yeah? What is it? What's the rule?
The rule is that you fill out the form. and we have a
What
discussion
number
about it.
rule is that?
1.4.
And where is it posted outside?
You're aware of it.
Is it posted outside?
You're aware of the rule.
Is it posted
I
outside?
don't know. I don't work out there. I work in
It's
here.
not posted outside.
Are you aware of the rule?
I'm not aware of any rule because it's not
Well,
posted
you're aware of the rule
outside.
because you had a discussion with Judge Tenney about it. Okay.
So you're going
Yes,
to
I am. So
not even let me speak?
you're aware of the rule. Fill
Are
out
you
the
gonna
form.
let me explain the situation, sir? Can I?
There's no situation to
There
explain.
is actually. There is.
There's no
And I,
situation to explain.
so I had a paper jam, so I didn't have time to organize this, so if you can give me a second. I have my oral arguments regarding this whole recording situation.
Sir, if this recording situation was that important to you, you would have appealed Judge Tenney's order, which was issued over 2 months ago, and you didn't, did you?
What order?
There was a contempt order issued. Okay, there was an order that you
So
had to comply
what?
with the court's rules. You have
Correct.
5 minutes to make a decision. I'm coming back in 5 minutes, fill out the form or not.
That's
Okay.
fine, so we can argue, I can argue this during the contempt hearing. So I'll get that ready for that. So, like we thought,
Yeah.
he's gonna be protecting jealously the contempt powers of the court. And so this is how it's gonna go down.
Frank, if I would make a recommendation for you, and you won't like it, but I'm just gonna say it. I would just go along with it,
I'm not going along with
Okay.
shit.
only because then it's like,
Not
it brings down the
going along
open
with
now versus
I already
later.
have, bro, I have this motion to stay the contempt order already prepared here,
Okay, I get you.
okay? So we got that. I got the memorandum here, he can read that while he holds me out back. And then he can decide if he's gonna hold me in jail, which is fine by me.
He cited the rule, but I like to see it in writing, like,
And it says, I have it, it's one of my exhibits.
yeah.
It says, all persons shall be allowed to record. Shall be allowed to record,
Not may.
okay? And so I'm gonna appeal to you gentlemen, who are supposed to be upholding the laws of this state, and particularly the Constitution. Turn this off. And you're not objecting to me creating my own record in my defense, correct? If I was to be creating my own record as an ADA accommodation, and I'm a party of record. I'm not a member of the public. So he has more rights than me. This gentleman right here has more rights than me. He's allowed to record my hearing, but I'm not allowed to record my hearing. Shall be granted. So, this is crazy. So here's the
But I
memorandum.
think he filled out the form.
Yeah, but the form
And the
is,
form is advanced notice. It has
Right.
nothing to, it's not a permission slip. And it shall be granted unless there's an objection. And unless it's disruptive,
Frank, I think
It
it's
has
for
to be
the-
allowed.
I can't enforce court rules, I think it's the judge that does that.
Frank, can I make another recommendation?
the Constitution trumps these rules.
All you have to do is notify the court. You don't have to fill this form out. This form is substantial. So if you just tell the judge, because he was asking you if you were recording, he's like, I may or may
I
not,
told
right?
him I may or may not be.
But I think you should say that I am recording. Only reason is because now you didn't have to fill out the form and you've notified the court. And if he doesn't respect that, then it's like, it's on him. You know?
They're notified, bro.
Okay.
He's assuming that I'm recording, so
But that's, I know it's silly, but it ends up being permission at the end of the day when you have to notify them.
this is one of
Because
my.
if you don't, but it's the funny thing is because the only people that can object my notification, the judge can't even object it, according to the clerk. Only the prosecution and defense can object. So how can he object to not even having it? You know, that doesn't make any sense.
Well, how can he grant you, let you record, but not let me record?
I
That
agree.
shows
Yeah.
that there's no issue with any sort of recording. So, here, I think this one too might go there. I guess there was a paper.
I should have brought my copy.
And then I got this 73A. So this order from the Supreme Court, which is where all these rules were created, is based off Rule 54 rulemaking authority, which comes from Article 73A, Part 2, 73A. And this order here is signed and attested to only by the clerk.
Yeah, 148 just says that unless
It
it's
has
an
to
objection,
be attested to by the Chief Justice and a majority of the justices.
There's no objection.
This is the only thing, this order is where Rule 1.4, Rule 19, and the other rule come from. Right, so yeah, this goes with this. This goes with And clearly, you can see this guy had his mind made up. And we're gonna keep doing this over and over again. So you guys could also, I was held in jail for 2 days for a non-jailable offense. There are no contempt powers, there's no penalty. The only thing they can do is remove the person if they're being disruptive and recording. If they're being disruptive and recording. So disruptive is a prerequisite to.
It's funny that they capitalize Associated Press like they have extra privilege.
Right. Well, that's the thing. So you're telling me the press has more right than the defendant?
Associated Press is a company.
Right.
So why is it that they're capitalized? It's kind of funny. And funded by the federal government, by the way. So it's kind of ironic.
And so this is for you guys as well, which really breaks down all of that.
Doesn't this cover it right here?
What is it? Yes, but persons are the media and the public is what they're talking to. It starts here where they say persons, all persons are prohibited for blah, 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 blah. But it also says in 1.4, where's rule 1.4? Can you, where it says shall? I was trying to highlight it. Rule 19. So that's like, so this is the other thing. It says no more than one still, this is for the Supreme Court rule.
Sure.
But it says no more than one still photographer and one videographer may be in the courtroom at one time. So you're telling me now that he's recording, I'm not allowed to record my own hearing? No, that's not how it works. So he has more rights than me as far as he's gonna trump my due process? I don't think so. I'll go to jail over this thing over and over and over and over again, and we will never get this trial done.
Again, we know.
So you guys can no process is all I'm saying, and then this can be over and done with. So that's on you, what you guys want to
We
do.
haven't got to the merits of the case yet, though.
Correct.
Yeah, that's what we're.
But I'm looking at, judicial expediency. You guys got jobs to do. Is it worth your time and the court's time for a registration, a maximum $100 penalty, no jail time, to keep jailing me, having me jailed for contempt, for not even, there's no order against me not to record. There's no specific order against me not to record my own hearing. And the only reason they could do that is if there was privacy issues or something like that, and it has to be predicated on an objection started by you guys. You guys need to object. That's why he asked, do you object to him? No, you don't object to him, and you don't object to me. Exactly, so it shouldn't be an issue. So if
Yeah,
you
and
can come to my
it is just
defense and say,
covering.
Your Honor, I don't care if he's recording, I would prefer that we move this case forward.
The judge is enforcing the court rules. It's his
I
position.
don't
The
see
court
how
rule
it's being enforced.
is predicated off of, you're saying that this trumps this, Article 73A. The Chief Justice of the Supreme Court shall be the administrative head of the courts. The Chief Justice shall, with the concurrence of the majority, make rules and the administration. Such rules have the force and effect of law. And the only enforcement clause in here is if someone's being disruptive, they can be asked to leave. That's it. That's the only enforcement clause. There is no contempt powers in there. There's no authorization for any contempt. So that's what I'm going to get into with him. I understand that you guys really are between a rock and a hard place here, but no. I have a right to due process. I have a right to create my own records. I have ADA accommodations. This is an auxiliary aid for my memory, as well as constitutionally protected activities, particularly for a pro se defendant.
All right.
No, those are for you guys.
Be seated. All right, Mr. Staples, again, three choices. We're fill out the form, turn off the camera, or we can hold you in contempt again for failure to comply with court rules. So, you made a choice?
I'd like to give my oral argument here to you.
You can
Before
give an argument
before we move forward on this, if I can say a few things.
about the camera issue?
About this, yes, this entire situation, this whole contempt thing.
Well, we're gonna have a contempt hearing, if that's what you wanna do.
Sure, we can have a contempt hearing, right? Do you wanna do it right now, or do you wanna put me in the back real
I'm
quick?
gonna take you into custody.
Take me into custody, and then we'll come back.
Open two are holding, one coming under.
So leave all my stuff here?
Turn the camera off.
I'm not turning anything off, and you can't turn my things off either. That would be destruction of evidence. So you're on notice
You're in custody.
that if anyone shuts off any of my
Let me give you
devices.
one additional warning, okay? I'm aware, because I was in the building, that you had a screaming fit the last time you were.
I did not have a screaming
Adhere
fit.
to the walls, okay?
Okay, please.
So if there's gonna be more of that behavior today, I'll hold you in contempt for that as well.
So
I will hold you in
has
contempt
there
for that as
been any of that?
well.
has there been any of that?
I'm giving you a warning ahead of time.
Oh, please.
All right.
Give me a break.
I'll see you in a little bit.
If there's gonna be any of that. Well, how come during the oral pronouncement, he said I was held in contempt and jailed for being disorderly? But, yeah, we'll see, we're gonna get into it.
Here we go again.
Yep.
I think that's the apartments right here, aren't they?
The what?
You guys take this stuff?
I'm not.
I'm bringing it out
I
back.
was his ride, so
Yeah.
I can do that.
This is
No,
the
I'm
stuff
gonna
that
bring
you
it back. All right.
You wanna put this back?
You can, if you wanna put it in the back.
I do know that gimbal, if it could be damaged if you just put it in like a way like that.
No, I'm gonna hold on to
Okay.
this. And then there's a piece of mail there as well.
You know what was funny though is when I talked to the clerk when I filled out the form, I was like, "Do you need the judge to approve this?" And she's like, "No, there is no process for that." Funny thing, in Hillsborough, the judge denied my form, and then I get arrested in court, not even for contempt, for disorderly, and I wasn't even disorderly. But you
Karen, I
can.
guess.
Yep. See
We'll see
ya.
you. Take care.
Yeah, you leaving?
I think so, yeah.
Oh, jeez. All right.
Yeah, you can, we have other hearings, so
Yeah.
Right.
we're not gonna, he's not gonna be back in here for a contempt portion right away.
How long are you guys keeping him for?
I don't have.
If you
control.
could make a guess, I mean.
I can't guess on
Okay,
that.
alright, fair enough.
It's gonna depend on it, he's gonna have his hearing, so
Yeah.
Okay. Like, could you give me like like kind of a time frame ish?
probably not till this afternoon for the hearing.
This afternoon.
Yeah. Yeah, we have other cases that have to come in.
Okay, I'm just thinking like, and how late do you guys stay open till?
4.
So it wouldn't go past 4.
No.
No, yes, you are. You held me in contempt, correct? You held me in
Why I
contempt
shouldn't?
because there was no disturbance, sir. What was the disturbance?
You came here intending to disturb.
I came here intending to disturb, but did I? Regardless of my intent, did I disturb? Did I create a disruption, sir?
Go on, make your.
I'm
argument.
asking you if I created disruption because it's this Supreme Court order is predicated on a disruption. You can only remove someone who's being disruptive in recording, not being non-disruptive. And it applies to the public and media. It's not intended, because you could limit to one media pool, one camera, right? But you can only limit the public. You can't limit a party, and I'm also right now putting you on notice that that device is an auxiliary aid that I need under the ADA, okay? It is for note-taking purposes, and I have my oral arguments, so I gotta get them out of here, and I have an emergency motion to stay this proceeding, and I have a habeas corpus petition for the Superior Court as well. If you're inclined to put me in jail, my suggestion would be for us just to have the hearing, to have the trial, since you've already confiscated my device, which is what you should have done. You could have just took the device, stopped if that was the disturbance, then you could have just stopped the disturbance, because that's all that's authorized by the invalid Supreme Court order. Okay, so this is, my emergency motion. I'll do this first.
You have a written motion?
Yes. You wanna see
Which one
it?
is it?
I need to sign it. Okay. So that's my motion. And I'm asked to be released from custody immediately, particularly seeing as you're violating my ADA rights and due process, speedy trial. This is the second time. And I have a memorandum as well that goes with that. And I would like to read this memorandum into the record. Once you're finished, let me know.
Okay, let's skip over this.
You're finished? You
have
skipped
written-
over?
You have a written
I
memorandum
have
of law.
oral, I have a written memorandum, yeah,
Memorandum of law.
correct.
Okay, I'll take that as well.
Take that. So, Your Honor, I am the defendant appearing pro se. I may or may not have been quietly recording as of right under Part 1, Article 8.
Let me stop you there. Are you just reading what you handed me?
No,
This is
I'm not reading what I handed you. This is my oral argument script.
Okay, go ahead.
I was prepared for this. I knew you were gonna do this.
Go ahead.
I'm 10 steps ahead of you,
Go ahead.
okay? So, are you not my substitute? Accountable to me at all times, sir? Yes, you are. You know that. Okay? So as of right under Part 1, Article 8, to preserve an accurate record of my own public hearing. I have a right to record public officials in the course of their duties. I may or may not have been broadcasting. Either way, I was not disrupting or inhibiting the proceedings. In fact, you seceded, you had a secession of the proceedings. You stopped the proceedings absent any objection from the Sheriff's Department. So, I also note that under Part 1, Article 2B of the New Hampshire Constitution, the people have a right to privacy. I do not have to disclose, I have no obligation to disclose whether or not I may or may not have been recording unless the court has a lawful basis supported by constitutional findings to require that disclosure. Moreover, New Hampshire RSA 644-21 searches of portable electronic devices. The law clearly states, no information contained in a portable electronic device shall be subject to search by a government entity, including a search incident to a lawful arrest or for inventory purposes, except pursuant to a warrant signed by a judge and based on probable cause, or pursuant to a legally recognized exception to the warrant requirement. A portable electronic device searched pursuant to this paragraph shall be returned to its owner as expeditiously as possible. And I'm asking for that device to be returned to me now. Again, I will reiterate my ADA accommodations. Okay, I require it for ADA for my head trauma. I have memory and processing issues. I need it to be able to review. It's just like taking notes. And sometimes I forget, and I can't do two things at once. So I need that, and you can't force me to have to pay for a record that you guys may or may not have. Okay? So, paragraph 3 of 644.21, evidence obtained in violation of this section shall not be admissible in criminal, civil, administrative, or other proceeding as proof of a violation of this section. A person injured by a government entity as a result of a violation of this section may file a suit against the government entity. If you can't search it, you can't seize it. Not only was my device seized, but I was seized. And your order, which we will read because you clearly have not read it, the only enforcement clause is removal of a disruptive individual who's recording and a temporary confiscation of their device. Okay? So, rules 1.4 and 19 apply to public observers, not parties. The rules governing recording, Rule 1.4 and Rule 19 in the Supreme Court, apply to members of the public and media observers attending proceedings in which they are not parties. I am the defendant in pro se capacity. A defendant cannot have fewer rights to document his own case than a spectator in the gallery, as we have here. Even if the rules apply, they guarantee the right, not restrict it. The text of Rule 1.4 states that, quote, any person shall be permitted to photograph, record, and broadcast all court proceedings that are open to the public, end quote. That's the rule. Shall be permitted. That's these people, not me. Due process requires that I have more rights than these spectators in the gallery. So, shall be permitted is mandatory language in New Hampshire and creates a duty to perform.
Can I ask you a question?
What?
Why are you yelling? I can hear perfectly well.
Sir, I have head trauma, and under the ADA, again, I will ask you,
You don't have rights to
I get excited and I have a loud voice. Get Frazier in here, the former the former prison guard. No. I have a loud voice, sir. I can't control the volume of my voice when I get excited. Okay? I don't care. There doesn't mean that there's no reason. I am disabled, sir. Which is why I've asked for my recording device as an auxiliary aid under the ADA. Again, I will reiterate that on the record.
Okay, go on.
Oh, thank you.
Go on.
Okay, so is the volume of my voice disrupting the proceedings? I'm not allowed to speak?
You're allowed to speak. You're just
Oh, just not in the tone that you don't like.
being excessively loud.
I'm being excessively loud. Give me a break. Go ask Frazier. He'll tell you I am not being loud. Okay, you have not heard me yell. This is my normal tone of my voice. No,
Make your argument.
listen, don't test me. Don't push me.
Make your argument.
I am making my argument, and I'm pushing back on you and your tyranny.
Uh-huh.
You are you are way beyond the pale here.
Make your argument.
I am making my argument. How do you square any of this? Rule 1.4 positively affirms this right, which cannot be denied. It is a duty. It does not restrict it, particularly for a pro se party creating his own records. Under Rule 1.4F, the court may not act on its own. Your own rules. Before the court can even consider restricting a recording, Rule 1.4F requires that, quote, the party seeking to limit or preclude recording carry the burden. That means the state, not the court, must object. So I respectfully request that this court ask the prosecuting sheriffs, which we already got them on the record. They did not object. They did not object to me recording last time, this time, and they didn't object to anyone here recording. Okay? So they're not here. If the sheriff's office does not object, which they did not object, the court has no authority under Rule 1.4 to act sua sponte. In my last trial, the sheriffs did not object at all. No enforcement authority, privacy, search and seizure. None of the rules or orders cited, including the November 16, 2021 order, contain any penalty, contempt clause, seizure authority, or enforcement clause. The only enforcement reference is against a disruptive observer, not a quiet litigant, i.e., no disruption, no cause for action by the court on behalf of the sheriffs. And most importantly, I cannot be compelled to disclose whether I'm recording without violating my rights of privacy. Okay? Nor, as mentioned, can my device be inspected without probable cause, a warrant, or a lawful particularized order supported by constitutional findings. That would violate Part 1, Article 19, and the Fourth Amendment, which this does. I'm seized right now. I'm illegally seized. Unlawfully seized, not illegally, unlawfully. So systemic lack of notice and due process violations. There is no public notice in any courthouse that I've been to explaining that Rule 1.4 exists, that recording is allowed, or that a notice form may be submitted. They hide these things from the public. The only thing that's out there is signs saying no recording, and the signs don't cite a rule. It doesn't cite Rule 19, it doesn't cite Rule 1.4, and none of those rules, nor is this order posted out there for the public. So whether or not I know what these rules are doesn't matter. There is no notice. There is no public notice. Okay? In Franklin, Manchester, and other courts, clerks have told me they've never heard of anything or of any recording form. In fact, this gentleman today, he called me after he was here getting the form, and he said they didn't even know about it. They said there is none. There's nothing. So the courts aren't even following their own rules, and they're using this to abrogate our rights. And like I said, again, shall be permitted. Shall be permitted. So you're permitting him to record, but you're not going to let a pro se party record. It's unbelievable. So only after pressing, just like in this instance, did in these other courts, clerks and court security find inconsistent documents different in every court, which allow for a notice, advance notice from the public is not, it's not about permission. It's notice and shall be permitted. So, how do you square that? How do you square that? You can't. Court security officers themselves do not know what the rule is. When you ask them, they say, I don't know. I don't know. And I got all the video to prove it. And I want to submit that video today. I have an extensive video, and I need my phone for that. Okay? So we're going to get into that video that shows the disparate treatment, and that I've been recording in courts for over 5 years with no issues and no contempt. And so I know that you're relying on the previous contempt and whatever happened that day, because you've already put on the record that you heard me yelling and screaming. You already said you intended to be disruptive, like you're a mind reader. So I'm disqualifying you from this case. You need to recuse yourself from this case, and you need to get these cuffs off me now. So I have multiple videos of officers incorrectly citing Rule 19 in lower courts, district courts, where it does not apply, and admitting, ultimately, that they did not know the rule at all. Under Lambert v. California, a rule cannot be enforced where the public has no notice, and even the state's officers do not know or understand it, let alone incapable of articulating anything legally valid or coherent about the rule. So they don't even know what they're enforcing out there. Why? Because it's not cited on the sign. If it was cited on the sign, all the court security out there would know right away. Hey, no, it's Rule 1.4. It's Rule 1.4. Yeah, that's the rule. Oh, it's posted right over here on the wall, sir. There's public notice. Why hasn't that been done? I've been here for months and months and months coming in here, talking to the clerks, talking to the judges, talking to the court security and the sheriffs. None of this has been corrected. None of it. You just want to say, whoa, well, you know about it. The public doesn't know, and there's no public notice, and that's what counts. ADA accommodations, independently authorized recording. I also have ADA accommodations due to cognitive and memory impairments. Recording is a necessary auxiliary aid for comprehension and review. Under Title II of the ADA and 28 CFR Section 35.130B7, the state must modify any conflicting policy. Must modify. And the fact that I'm not signing it is also part of my disability as well. I'm not going to comply with something that I don't understand, is not fully explained to me, and not giving me public notice. I follow the law, unlike this court and you. Okay? In this instance, federal law is supreme. A restriction on my ability to record would violate the ADA and constitute prohibited retaliation under 42 U.S.C. Section 12203. 8. Constitutional foundation. Recording my own hearing is protected by Part 1, Article 8, accountability of officers' right to know. Article 14, access to justice and an adequate remedy. Article 19, security from unreasonable search and seizure. I know you're like, you don't care, right? You don't care. Article 2B, right to privacy. You think these little rules trump the Constitution, sir? Is that what you think? I hope not. We'll see at the end of this. Article 37, separation of powers, and the First and 14th Amendments. Without an accurate, timely, and affordable record, I cannot effectively participate, litigate, or appeal. Actual notice by state agencies. The state, including court security, state police, and sheriffs have been fully aware of my recording practices in the courts for over 5 years. Justin Jordan Hazy, head of court security, has acknowledged viewing my YouTube documentation. Despite this long-standing notice, no agency has ever objected or taken enforcement action. In fact, some court security have admitted on camera that it is not a problem unless there's a disturbance. Their continued non-objection demonstrates that my conduct is not considered unlawful or disruptive by the state itself. This weighs heavily against any restriction of contempt today. Hold on, and my papers got mixed up. There's one more piece of this somewhere. So, Your Honor, respectfully, there exists no lawful order, no notice, no penalty clause, no Rule 1.4F motion, no state objection, and no constitutional basis for this contempt. Any attempt to sanction me for quietly recording my own hearing would be ultra vires and a violation of Article 73A, due process, and my rights under the ADA. I'm simply maintaining an accurate, private, quiet record of my own public cause. I am simply, which the Constitution protects, the rules permit, the ADA requires, and the state has never objected to. Okay? Oral arguments. And I have this as an exhibit. This is the order. This is the November 16th, 2021 order. Are you familiar with it?
Yeah.
Are you aware that it's only attested to by Timothy Gudis, the clerk? Does the clerk have rulemaking authorities under 73A?
Are you done?
No, I'm not done. I'm asking you a question. Does the court have? Does the clerk of courts have rulemaking authority under 73A? No, he does not. It's a majority of the justices in concurrence with the Chief Justice that can make the rules, and it must, under 73A, bear the Chief Justice test and the other justices' test. Not some printed off document that has no docket number, no way to investigate. I have a video which I'll show of me asking Gudis about this, and where's the docket number, where's the oral hearing, where's the public notice about this rule when it was made, all those type of things. Nothing. He said, this is it. This is all that there is. And so, because it only bears his test and not the test of the Chief Justices, it's null and void. It has no force of law. And even if you think it did, it's about maintaining a safe and dignified environment that is free from unnecessary disruption. There was no disruption. Okay? So the whole point of this is about disruptions. All right? Disruptions. So, through extensive research into New Hampshire's legal system, I have uncovered a pervasive pattern of constitutional violations stemming from the systematic abuse of Supreme Court Rule 54. This investigation reveals that the administrative judges across multiple court divisions have been issuing administrative orders that violate New Hampshire Constitution Part 2, Article 73A, and fundamental separation of powers principles. The violations extend far beyond the November 16, 2021 Supreme Court recording order signed by Timothy Gudis, encompassing family courts, probate courts, circuit courts, and administrative systems statewide. Constitutional framework violations, Part 2, 73A, the exclusive authority structure. New Hampshire Constitution Part 2, 73A establishes that the Chief Justice of the Supreme Court shall be the administrative head of all courts. He shall, with the concurrence of a majority of the Supreme Court justices, make rules governing the administration of all courts in the state and the practice and procedure to be followed in all such courts. The rules so promulgated shall have the force and effect of law. And then I need my phone because it also says that it must bear their test, which you know if you've read it. It must bear their test. Not, it might be in 73B, but that's why I need my phone to be able to look that up. So the constitutional provision, this constitutional provision creates 3 non-delegable requirements. Chief Justice authority, only the Chief Justice can serve as administrative head. Majority concurrence, all administrative rules require majority Supreme Court approval. Legal force, properly issued rules have force and effect of law. Again, this is not a properly issued rule. This does not bear the test of the Chief Justice or any of the other justices. So it is, in effect, words on paper. Rule 54's systematic constitutional violations. Supreme Court Rule 54 violates Article 73A by creating an unconstitutional administrative structure that delegates exclusive constitutional powers to subordinate administrative judges. The rule enables administrative judges to issue orders with force and effective law without required majority of the court concurrence. Family court system, extensive constitutional violations, administrative orders issued without constitutional authority. Circuit Court Administrative Order 2011-01, signed by Edwin W. Kelly, Administrative Judge, demonstrates the systematic pattern of constitutional violations in the family court system. This order, addressing counsel appointments in abuse and neglect cases, was issued under the purported authority of Rule 54, but lacks the constitutional foundation required by 73A. Key constitutional defects. No
Mr. Staples, how much more do you have left?
Oh, I mean, I got a lot left here.
We've got 5 minutes to get this done, okay?
Well, we could continue it then.
We got
And
5
I'm gonna
minutes to get
ask,
this
I already asked you to stay the
done.
proceedings.
I'm gonna read your motion, I'll be back in 5 minutes, okay?
Okay, you do that. Thank you. All rise.
Tell me to rise when I see rising. Frank, you're doing great.
Thanks, bro.
Yeah,
I would prepare for this, people.
You were.
I'm double barrel.
Double cuffed.
Yeah.
Triple cuffed, actually.
Triple cup.
Triple cup.
Seriously though, I'm ready. We're not done here.
You know
We're
what?
not done till I'm done. 5 minutes, bro? 5 minutes? So you want to hold me in contempt and then tell me I'm limited on what I can
The last time,
argue for my defense?
you went out for 5 minutes. It was like 10 minutes too.
Yeah.
Yeah, but
So you're taking
you have
a
as
long
long as you need.
break.
I have
but-
as long as I need.
But hey, what's really funny is like the sheriffs are here, the court sheriffs, whatever they call them, court security. Okay, they lied to me like immediately because I saw them, or I heard them talking to the police officers over by the cruiser about this case, specifically him, and they. And then I was like, "Oh, is Frank here?" And they're like, "Who? I don't know who that is." And I'm like, "You were just talking about him." And he's like, "I don't know what you're talking about."
If they don't watch my channel, they
Yeah.
should watch my channel. because they would learn something.
I know.
You can see like those sheriffs that were here, they do watch my channel. And they, you know.
If they, you know what's funny is like if they watch your channel, they'll have a better way to like fight against you.
Sure.
But
I tell them what
because
I'm
the
gonna
way
do.
that they're
They do
using
watch.
the way that if they do watch, they're not doing a good argument against.
But like Justin
not saying that
Jordan
you're
Casey,
wrong.
He watches it. Like some of the top people, they have people watching it.
Yeah, heck, they're probably using it in universities right
Fusion
now.
Center. Did I show you the Fusion Center data that they have from the Candlelight Vigil?
No,
Oh boy.
I mean they put fusion reports out about me too, and
Yeah.
it's
So
total
they're
slander.
using it to plan enforcement actions on peaceful protesters, and even their own emails, they're saying there's no credible threats and there is no criminal activity. We're not supposed to use this information unless there's credible threats or criminal activity. They mentioned Article 10 and Article 22 as the backbone of our state. And Article 10, do we all know what that is? The right to revolution. All means of redress are ineffectual. We have the right to revolution, and I would argue that this is my revolution. All of my means of redress have been ineffective,
It's
falling on deaf ears.
it's unfortunately an unnecessary revolution because it shouldn't be happening.
It shouldn't be happening. I shouldn't have to. I mean, it's crazy that you have more rights than me right now
Of course I do.
for my own.
I'm not in
hearing.
cuffs, Frank.
Yeah, you know. The longer he holds me, the worse it's gonna get. And if he wants to send me to the jail, let's go, bro. Send me to the jail.
I don't know.
So he.
You got a free bed and meals? You look like sound like you have more rights than
I'll
me.
talk to some of my CO buddies. Like, I'm cool with security. Ask Frazier about me. He'll tell you about me. I don't play games. I'm mad respectful, and I don't react unless somebody pushes back. If somebody tries to violate me, I am 100. I don't play games. I don't make shit up. I don't cause problems. I finish them. And he'll
You know,
tell you that.
I think
I know that's why he was called in. They called him in because he was one of the biggest negotiators with me when I did 5 years in solitary confinement. Always cool, good rapport. He knows how to talk to somebody. He knows how to be respectful. He knows how to have a poker face and not show their emotions in disgust.
You know what the judge
With
deserves?
Someone exercising their rights. He's disgusted. This guy's
Frank,
disgusted.
you know what the judge deserves? A drawing.
Yeah, you need to put it. You could just take it, draw an egg.
I'm sorry.
Draw
No.
an egg.
No. I mean, I could, but it starts that way.
So yeah, so now he just disrupted my my train of thought. So let me put this backwards.
He's getting tired too.
I wonder what the judge is doing in his 5-minute break, though. Is he like,
He's calling. Know what he's doing? He's doing like the last guy did. He's calling the Supreme Court. He's calling his
Verify
cohorts.
it?
Bro, you see this?
oh, he's trying to get the chief to
see
make a
that?
statement right now?
This is the manual, bro. This is what they do. This is all about the dirty things that judges do.
Is that yours?
Yeah.
No.
$125.
Wow.
May or may not be signed by the author. I may or may not know the author.
Incredible.
That's great.
So, yeah, I know what I'm talking about. And I will prevail. And I win even when I lose. Frazier will tell you that. When I lose, this is winning.
It's probably
This
a bigger
is
win.
winning.
It's a bigger win.
This is a winning, yes. This
Because
is
just to let
winning.
it go is like a loss. You're creating precedence.
Absolutely. And I'm inspiring people.
I know. I think one of the worst things they ever did to Ian was to send him to prison because he.
Now educating everyone.
Oh my God.
Planting seeds and
Oh,
telling
jeez.
them about Bitcoin.
Appeals.
Yeah.
Like
Yeah.
I didn't know how to
here's
do
something
that.
else I want to note here. This order, right? He was like, you didn't object to his order. What am I going to object to his contempt? I was held in jail. What am I objecting to? What's gonna be overturned?
Oh yeah, like who
Well,
doesn't
he's gonna
want?
get a federal lawsuit, and it's gonna be a conspiracy with this guy and this guy. I got a whole investigation on this courthouse. That's why they don't want me to record, because I already got the goods on you. And this is just the icing on the cake. You're playing into my hand. I hold all the cards, and they're all aces. Kneecap.
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 What is that? No cap?
No, kneecap.
Rapper. Irish rapper.
Irish rap.
Oh,
They say that. Hold all the cards and they're aces.
good.
So yeah, I stole that from kneecap.
It's a good line though.
Boom, boom, boom. So yeah, the dark side. She was married to Chuck Douglas. Ah, yeah. So you're telling me she doesn't know all this? And she was a legal beagle herself, right? And got attacked. But yeah, this exposes the dark side of judging. All the dirty tricks that they play. The court is like a country club. Country club rules. Membership in a bar, unauthorized practice of law committee. Judges are a secret elite. Oh yeah, there's all kinds of
you're not supposed to say that. Secret.
It's a secret.
We're having fun in here.
It's a club, and you ain't part of it.
I mean, oh yeah, you know. But what I was going to say is, in this order, Judge Tenney last time says he's putting me in jail just because I refused to sign the advance notice. But on the oral record, which is the one that counts, because he wrote this after, he said, well, I heard what you had to say, and you were disorderly earlier, which is not what I was held in contempt for. Supposedly now all of a sudden there's this.
Oh, I love the disorderly after the fact.
After the fact, now there's a
Those are
disorderly
good.
in there, even though. And then he also said, and you just swore at me, so I'm going to put you in jail for a day. Well, there should have been 2 other separate contempt charges by the letter of the law. But no, they don't want to do that. They just want to, flex and act like they have judicial immunity, and it's not always, that can be pierced. That judicial immunity can absolutely be pierced, and this guy has already been sued in federal court for constitutional violations. Or no, this is a different guy. I'm gonna have to look into him. That was the guy I was expecting, Katsavaris.
Is that why they switched him out?
Service or whatever. Yeah, because I posted that this is who I'm expecting, and so this is what they do. They're
I wouldn't have posted that
They're-
because then if he showed up, then the whole case gets thrown out.
No, what they're doing is well, he already admitted on record that he's holding me accountable to my previous behavior for the other
Right,
trial.
right. And
So he's
from
already
Oh, yeah.
screwed himself. He's already shown bias.
wait, I can read your mind right now, Frank.
Yeah, you intended to. so it's pre-crime because he thinks I intended to be disruptive. That he can. So I am being disruptive. Let's act like he is being disruptive, even though he's not being disruptive. Yeah, that's why he can't square it, and that's why he started to sweat. He thought he was like. He slowly started to realize that his pocket twos were not gonna.
All rise.
Only the dead rise.
All right. Mr. Staples, I'm gonna hope that you give me the courtesy of listening to me. I gave you the same courtesy, so.
I'm not finished, but yes, I'll hear you out and then I can have my turn back. Thanks.
Here's my ruling, okay? I've looked at your motion. Just gonna go through the arguments you made one at a time. You say that these rules aren't applicable to a party of record. I don't see any distinction in Rule 1.4 between parties of record or members of the public. It says any person. And it says no person shall be permitted to record without complying with the rule.
So
in
you're
terms
just, okay.
of- Don't interrupt, right?
Oh, like you were doing to me earlier?
You were on notice of the contempt. I gave you clear directives, choices, and you made your choice. In terms of a sua sponte restriction, this wasn't about the restriction, this was about you complying with the court orders, which I believe you came here with the full intent not to do.
What court order?
And the 1.4, you know the.
That's
rules.
not a court order.
Okay, court rule, okay? It's a rule that you knew was in effect. The order was, very clearly, comply with the rule or
What
the
order?
consequences.
Whose order? Cheney's order?
My order, verbally, to you, this
Oh,
court
oh,
earlier
oh.
today.
And
So
so what's
you
your
were-
relation to the previous case with Tenney?
Let me explain that too. Any file that I get put in front of me, I review it, okay? I looked at the file. I'm aware that you were held in contempt before. Beyond that, as I explained to you earlier, I was here that day, and I could hear you through the walls, okay?
That was not in the courtroom.
You were,
That was when I was out back with him.
you were in the courtroom. My chambers are directly across from courtroom 1. I could hear you
Talking?
screaming, okay? I heard you,
Like you were just
I'm
saying. I was
aware of
yelling.
your case.
Yeah,
okay?
screaming, yeah. I just have a
This
loud
isn't-
projecting voice.
Keep listening for a minute. This case isn't about, or the situation is not about a penalty inherent in the statute. This is the court's inherent power to enforce its own rules. That's what contempt is all about. If you're in contempt, I have the authority, the obligation to enforce the court's rules.
And you
That's what
did.
we're doing.
You took my device, which is all that's allowed, and we could have just had the hearing. But now what? We're gonna have to continue it? Are we gonna have the trial today? Are you gonna send me to jail on top of holding me out back?
Let me talk about the ADA. The ADA does not excuse compliance with minimally burdensome court rules. It doesn't excuse disruptive behavior. It doesn't excuse any of the things you think it does,
Sir,
okay?
sir.
So,
Sir,
I
you
know
said I was
the
not
ADA
disruptive.
as
Sir, no, you said I was not disruptive.
you've been disruptive since, so.
I've been disruptive since? By
It's-
what?
You keep
Speaking?
cutting me off for one, so keep your voice down and listen.
Stop yelling.
All right, so again, my take on this is that you came here with the intent to not comply with the rules. knowing
What
that
evidence
this
do you
is
have for
wrong.
that? What evidence do you have
You
for
were held
that?
in contempt once, you came here, didn't fill out the form, and you had your recording equipment out without having filled out the form. You came here intending to do this, this is the result you wanted, and so you're gonna get the consequence you wanted.
What's that consequence that I
As
wanted?
this
What's the
stands-
consequence that I wanted?
Psychic. As this stands.
This?
Stop interrupting.
Send me to jail, because that's what I want you to do.
I already warned you, if you engage in disruptive behavior, you can get a second contempt charge going, okay?
Go.
Interrupt me again, that's what's gonna happen,
Oh, please.
all right? I am compelled to find that 1 day in jail wasn't sufficient to dissuade you.
It was
from
2.
non-
It was
sentenced
2
to one.
days.
I don't, whatever happened at the jail is not up to me. But you were sentenced to 1 day in jail, okay? And that apparently wasn't enough to dissuade you or convince you should comply with the court's rules, minimally burdensome rule. And so.
No, because
I
you can't
failed to
explain
find
the
that
rule.
You're gonna be sentenced to 3 days in county, okay? That's my sentence. And I'm denying the motion to stay, I don't find it meritorious.
I have a habeas corpus.
That's my ruling.
I have a habeas corpus. Jesus Christ. Where is it? I have a habeas corpus that I need one of these
All
guys
rise.
to file for me. This is insane, bro. I need you to go to the Superior Court
Yep.
and file this habeas corpus. Wherever, I don't even know where it is. And, tell them that this court is holding me in jail for 3 days for an unregistered vehicle thing. Where is it? We had an issue with the printer jamming at Staples, and
Can't confirm.
maybe it's over here. Notice of corrections officials. Where is? So this I need to give to corrections officials. And I don't know where, not him, to the jail. That's for me to give to the jail. To preserve my stuff. And, can I just give stuff to them so that they don't have to process it at the jail?
Yeah.
Yeah.
Frank.
So what the hell was up?
You want me to give you the keys to you want to give me the keys to your car and I can put your stuff in your car?
They're in my jacket.
What's in okay.
Yeah, so if you can put the stuff in my car.
Yeah.
So. This guy's out of control.
Do you need me to go there today?
Yes.
Okay.
And you need to tell them
I'll bring you.
to call the jail and order them to release me immediately. Okay, take this and let them know what's happening here and that they keep, now he's putting me in jail for 3 days. I didn't even cause a disruption. You have the,
He only announced that right at the end there.
what is it?
He only said you were disrupting at the end there. You've been disruptive.
I've been disrupted.
After you mentioned
Then
it.
why didn't I get charged for being disruptive?
Right.
That's the
Right.
order, and it says it must be disruptions.
Correct.
So, I have a habeas corpus petition. Maybe I left it on their table. Shit, man.
You don't have access to the phone to email it or something?
Well, I don't know what happened to it. What is it?
You can't email it over to me or something? Will they let you have access?
Possibly after I give them that thing. Possibly, and I need to call somebody. So yeah, I don't know where my I don't know where this thing went. I had a habeas corpus. I know I had it. I seen it. Where the hell did it go? Who got my stuff out of there? Who brought my stuff back there?
Okay.
Packed everything that was on the table when they observed
Packed
and watched me do
everything?
it. Absolutely.
I'm not going to confirm or deny. I don't
Yeah,
remember.
you can't confirm or deny that. And you went out back. You packed it all up.
Everything went into that
Oh,
briefcase.
please, bro. How do I know? I printed this stuff off and now it's not there. My habeas corpus petition is missing. So you need to tell them that too, that I had a habeas corpus petition and it's missing. It is on my phone.
You wanted them to have your,
I have to be able to email it to him. No, he can't get into my
you can't
phone.
get into your home?
No.
Hey, breakingtheflaw@gmail.com.
I can email it to him from back there. You know?
This is okay,
And
fantastic.
that's for the corrections officials, right? So yeah, bro, go blow this up. Go mention. I don't know. Is this live?
No, it's not live.
Okay.
Now, do you want them to have your camera equipped?
Yes.
Okay. So if somebody can wait in the front lobby for me after. I
There's
get
a
it
thing-
back there, I'll bring it to you.
Okay. Sounds good.
There's a
Yeah.
plastic
Or the
protective
cover-
thing.
Yeah, I'll find it somewhere.
Yeah, it's in here somewhere. It's in one of those things. All right, bro. Thank you.
All right, Frank.
Hey Frank, I'll move your car if somebody decides to fuck with it.
Don't move it.
Don't move it?
Nobody should just make sure it's locked.
Okay.
Hey,
sounds
be
good.
safe, bro.
The red button locked.
All right. Damn, bro, that sucks.
I know. It's so stupid. You think that's really gonna solve? You think, how many more times do you have to hold him?
It's not bowling, bro.
All right, guys, we just had a Footloose, aka Frank Staples, trial for contempt of court, and guess what? No surprise, he was held in contempt again for recording. There was no disruption. Frank's argument is that the rule says that you have to be disruptive when recording for it to count in the court's rules, and the judge is enforcing a rule that was never indoctrinated by the Chief Justice, was never held in practice. So Frank even asked the Chief Justice directly at one point, and I'm hoping that we can get that footage soon. But Frank is being held right now. He was just sentenced to 3 days of contempt. 1 day wasn't enough, even though he was held for 2 days last time this happened. And now the judge gave him a little more of a punishment. So he's going to continue to do this. I have no doubts that he's going to continue to fight this and continue the same process, because he is not wrong on this case. He's showing how absurd the system is. So thank you for watching this trial. well, lack thereof trial, and it's unfortunate that Frank is being held again, but we're going to help him out, get over to the Supreme Court, and file some more motions for him. All right, guys, stay tuned. Breaking the Flaw here. Have a good one.
Oh, God.